Tell you what, ladies and gentlemen, we have a quorum present, and we all have to, without benefit of lunch nourishment, be in session at 1 o'clock, it seems. So in honor of you so dedicated to be here, I'm going to call this meeting to order. The presenter is on the way, Senator Rogers, but I thought we could use the time wisely in the interim by hearing from Mr. Clint Mueller from the ACCG, who was going to testify today anyway. Did I see Clint come in? Could somebody find him? And while we're waiting on him, is there any member of the committee which wishes to be heard on the proposition before us? You should have yet now another revision even from yesterday in front of you, which is LC 189233TS. I'm not sure. I just saw it 5 minutes ago for the first time, so maybe when we can get to... Okay. The chair would like to recognize, if he's ready, and you could come have a seat if you'd like, Mr. Mueller. The sponsor's on his way, and I thought we could use the time by getting at least your initial thoughts on this. Obviously, I know you may not be able to conclude those today, but we have in front of us LC 189233TS, which we understand is a Senate sub that happened this morning. And you're recognized, please, sir.
Thank you, Mr. Chairman, members of the committee. And I do not have a copy of the sub, by the way, so I'm going to work off what I have seen the sub, though, so I'll work off what I've seen and may not be able to give you the exact line numbers. Oh,
okay.
You want to? Let's.
Senator Rogers, we knew you were on your way, but to use the time wisely, we went ahead and recognized Mr. Mueller, if that's all right with you. And we're going to get some general comments from him, and then we'll hear from you on the changes in the recent sub. So, Mr. Mueller, if you would, please.
Okay. Appreciate y'all hearing from us today. Obviously, we have spent hundreds and hundreds of hours, I'll tell you, working on this piece of legislation. And I want to thank Senator Rogers. He's been completely open in this process. I can tell you in the 14 years I've been down here at the General Assembly, I've never spent as many hours on any particular bill as I've spent on this bill. Probably 3 times as much as I've spent on any other bill. So we have spent a whole lot of time working on this piece of legislation. And this truly is a comprehensive overhaul to the appeals and assessment process. It's the most significant change, at least in the time I've been down here, and I know Mr. Richard Roll has been down here a lot longer than I have, and I think it's the most comprehensive change that he's seen in his 25 years. So it is truly a comprehensive reform of our property tax laws, and that's why it's critical that we get this thing right, because a lot of what's in property taxes has been outlined in appraiser procedural manuals nationally, as well as our Constitution. So we want to make sure that we give clear direction to our assessors across the state as to what we want them to do. I think that what is in this bill, there's a lot of good necessary changes that have been made. There are some new provisions in the sub that we saw today, and I want to address a few of those issues. We do have one technical correction that we'd like to make to the bill, and I've discussed this with Senator Rogers already, and it has to do with the language that, let me see if I can find it here. It's dealing with the mailing notice.
You're going to give us a line and page?
Yes. Lindsay, do you know where that's at in the bill? Where we? Is this the page 12? Okay.
1398.
No, that's a different issue. Where we outline proof of notice when somebody receives.
It's 718. You're talking about the service of notice?
Yes.
Yeah.
Yes. Starting on line 718. This is dealing with proof of service, and I think our attorneys, along with the assessors yesterday, worked on some language that everybody was agreeable to, that we'd like to add to this section of the bill. And unfortunately, I don't have it for you right now this morning. One of the areas of the bill that I've been getting a lot of emails on is is in Part 5 of the bill. On line 877. It says, in no event shall future use be considered. I'm by no means an expert in the area of appraising property. I'd like for y'all, if you would, to hear from the assessors that I have here, but we're getting conflicting interpretations of what that means. And I'll give you an example. You may have a piece of property that's zoned for a high-rise building, but there's not actually a high-rise building sitting on that lot. Well, obviously, because of the zoning and the potential for putting a high-rise building on it, the market is going to be willing to pay a higher fair market value for that lot than they would a lot that was zoned something else. So the question has come up, can they consider the zoning as a future use when they haven't actually used it for that use yet? And I'd like for Steve with Gwinnett County, if he would comment on that.
Well, that's absolutely true. If say a small tract was zoned for an office complex, although the office complex was not on that land quite yet, that property would sell for more in an open transaction than a piece of property adjoining it that did not have the same zoning. So if we could come up with some type of zoning allowance, maybe not rezone it in the future, but what is its existing current zoning?
Excuse me if I think I've understood two circumstances. What I thought I heard Mr. Mueller say was it was already zoned but not fully developed. That's different. I mean, we always have had provision in uniformity that dealt with zoning. Even in last year's legislation where there was the assessment freeze, accepted out of that was a rezoning. We're very well aware that rezonings will change value one way or another. I mean, that's precedented all the way back to when we've had taxes. I think what Mr. Mueller is talking about is it's already zoned, let's say C2 or C1, whatever it is. The future use aspect is it's going to be worth more when it's developed. It seems to me like that's pretty speculative. If we're not changing the zoning, I certainly understand the change in the zoning, but the rest of that gets real speculative if you consider, well, we think that may turn out to be a gold mine.
Sure.
Just because we've never drilled down 2,844 feet, but we probably feel like there's some precious ore there. I mean, that you get a lot of speculation in sort of an unrecognized area. I'm not sure I understand what you're trying to tell us. And you are, by the way, you're an assessor by trade?
I'm the chief appraiser of Gwinnett County.
Appraiser. Okay.
What we're looking at, the language says shall not consider future use. We're standing before the property. The existing use is it's vacant. It's a vacant piece of property.
Okay.
But it is zoned to allow an office tower to be erected on that piece of property. So if the current use is vacant and an adjoining property is also vacant, but it still has an agricultural use or an agricultural zoning on it, which one is the market going to pay more for at the time that both are vacant?
I think without a doubt that the market is going to be the fair market value on the date of the appraisal as it is zoned. I don't think it matters that next door is a agricultural piece. I think from an appraisal discipline standpoint, you would do a comparable yet undeveloped likely zoned lot. I'm not understanding what the distinction is. Can you explain it better to me, Mr. Mueller?
No, this is and this is not an issue that was raised to me till yesterday. There's several emails that came through. I understand that the Constitution of Georgia requires us to value things at this fair market value, and some of the assessors and a former property tax director of the state of Georgia pointed out that you can't, if you don't consider future use, you can't actually consider what the market considers. Therefore, you can't put a fair market value on the property, which conflicts with the Constitution. I can tell you, though, that this is an area that's not. I'm just getting conflicting information about it. I don't know, and again, it was not raised to my attention until yesterday.
Well, I will tell you this, and I've always been straightforward and honest with
Sure.
you and the ACCG. You may have convinced these other members that there's some harm in this language, but I'm not there yet. So
No, and that's,
who's ever sending you these emails? I mean, I think that we're talking about a huge departure from very traditional appraisal discipline.
Right.
If we all of a sudden superimpose some very intangible, very speculative new criteria that we can just arbitrarily judge. I mean, that's the whole thing we're trying to get out of the law, I think, is the arbitrary treatment of property from a value standpoint from a property owner's perspective. And maybe Senator Rogers will tell us differently, but I thought that was his initiative in this. So.
right. And my thought actually was that if the Constitution says fair market value, and you believe that this language here somehow violates that, well then the constitutional provisions supersede anything that's in this bill, so that would override it. So if there's a conflict in your mind between
Right.
what's in the Constitution and this provision in the bill, you go with what's in the Constitution. So in my mind, that's why I didn't have an issue with this, and was trying to reconcile that with the emails I've gotten, because they were saying that it somehow violates the fair market value, but the Constitution says fair market value, and you're going to go with that.
I'm going to take these just left to right. Would you yield for a question or two, I guess, on this issue? Representative Abrams?
Thank you. Mr. Mueller, or to the assessor, my question is actually sort of the opposite proposition. Let's just say that zoning is C1, and it's being rezoned. It was C1, and you've rezoned a parcel of property or an area for mixed use, where the actual value could go down. How would this provision impact that? Because if it's been rezoned for mixed use, but no one's actually built a mixed use development, we have a lot of those in Atlanta where we've rezoned for mixed use from commercial, but the mixed use development had to stop because the money ran out. How would they be allowed to reduce, given the future potential use of the property?
It would be my opinion that the value of that property would be reduced because of the zoning.
Okay.
Another issue on future use is if we're doing an income approach to value, we are looking at the future income stream that we're capitalizing back to a current day value. And this...
You don't think that's incredibly speculative? You have no income producing element yet developed on the property, and you want to superimpose a future stream of income value to it?
My situation is you must have the building. There must be the income. I'm not talking about the vacant pieces of property anymore. But in the income approach, where a building is being leased and the property itself is generating income to the owner, that future income stream must be considered. Now, whether that is
I think
didn't
we've
have-
actually dealt with that very issue in the bill, because the net operating
we have
income of commercial properties is probably a primary derivative of value as opposed to comparable sales or whatever. Occupancies, rent rolls, all those sort of things dramatically affect the value on any given date from an appraisal discipline perspective, unless there's a lot of new stuff I hadn't heard of, and that's possible. That's why we're here. We're trying to learn those things, but I understand. Number 11, is that Representative Peake or Martin? Which one?
Thank you, Mr. Chairman. You addressed most of my questions, but just in all due respect, the reason so many of us are supportive of this legislation is because many of us and many citizens in our state have been hit with speculative appraisals that are completely outlandish and not realistic of what the real value is. The answer to this is, okay, when that property is sold, then you establish the fair market value. But until then, even though it may be zoned a certain way, there's no reason to put a potential future value on it just because of its zoning. And so I hope you understand our frustration that this needs to be in here for that particular reason. So.
Believe me, I do. I see the same things that you're seeing across the state. I work really hard in Gwinnett County for that not to be a limited issue.
And I'm sure you do, and I don't mean to disrespect that. I know you got a tough job, but the fact that we would potentially value something based on its potential use, I think, is a wrong way to go about appraising a particular value. So.
Chairman Martin?
I'll try to be brief. One of the things that I would want to be careful here, and why I like the language on 877 is many times people will zone an O&I project at 20,000 feet per acre. And when they come to actually develop the property, they may develop it at 12 or 15. They may do so. I'm real careful as to someone coming in and assuming that property is going to be developed at 20,000 feet per acre when property around it may have been zoned at 20 and be developed at 12. So I like the language, and I don't think it prohibits you from, if it's zoned O&I, giving that a little bit more value than if it were zoned ag. But we don't necessarily want to have you look into the future and zone it at 20,000 feet per acre because they might not actually build to that capacity. Is that fair? I mean, does that?
Sure. Yes.
Okay.
Chairman Williams? You want?
I think all of us share the same feeling about this, and on anticipation of something happening. Even if you had something out there that fell through, then what do? Do you go back and decrease the value of that land if you had a planned hotel or some commercial building and all of a sudden it fell through? Then you jack that price up or appraisal up to a point. It may be that nobody else wants it. I mean, a lot of anticipation there that I think we don't need to put in this bill to establish a value.
Oh, absolutely, but there must be demand on that same side too. In other words, if all of the property is zoned, for some big development, but nobody's developing in that area, if demand is not there, then the prices are not there either.
Back along the line that okay, once that comes to being, then we'll put an appraisal on it that would be fitting to whatever.
That's correct, sir.
Chairman Knight.
Thank you, Mr. Chairman. We've heard a couple different viewpoints here with the future, event could be considered. But I want to go back to, I think the whole purpose of what Chairman Rogers is trying to do is come up with what is fair market value. I mean, that is the issue here, is fair market value. And I know that when we traditionally, what little I do know about appraisals, you look at the highest and best use of a property. Is that correct?
In my opinion, not for property taxes. You may get a different opinion from a different assessor.
So what we're saying is,
That's the problem.
so
There's a removal of highest and best use in this bill currently.
So what we're saying is got to be based on a current use.
Current use, existing use.
But how does that line up with what I think what the Constitution, what everybody is or what I'm understanding is, what is the fair market value? What is the definition of fair market value? And I think that's where I'm trying to. You go back to your example of two lots side by side, one zoned, for a commercial use. It hadn't been used for that purpose, but the lot maybe next door, just across the corner, is not zoned for that use. Is there not a difference in the fair market value of those?
If there was demand for development in that area, yes, sir, there would be a difference in value.
Okay, I think, if you don't mind, I'd like to also, we've got our legislative counsel here, since the issue of constitutionality has been raised. Mr. Sawyer, would you speak to that as it relates to this phrase, and in no event shall future use be considered? What are the constitutional implications, in your opinion, as it relates to that phrase?
I would have thought that would require a constitutional amendment to accomplish that purpose. This committee recalls several years ago, no matter what the patent debate at great length, the process of the bona fide conservation use assessment, which essentially does just that. It's limiting those assessments to current use value only. The Constitution was amended to specifically authorize that as an exception to deriving fair market value. Now, in this case, too, please note that it's not just line 877. It's line 872. These are factors that before this bill would have been considered. They're no longer being considered. They're required to be applied.
Okay.
Moreover, I'm not.
Could you say that again? I lost you there. These are factors that.
72, the tax assessor shall apply the following criteria. The tax assessor now has to. Before the bill, the tax assessor would consider the elements listed on lines 874 through 886 in determining fair market value. These would just be an array of things the tax assessor would look at in terms of coming up with an overall fair market value of the property. If I'm understanding what this change on line 872 does, he has to apply all of these. So if you look at little double I starting on line 875 through 878, then the only thing the assessor can apply is the current use of that property. Now, how that will work in conjunction with what's being required up on lines 858 through 860, if income, and I don't understand these matters, but if income approaches, in one part of this is requiring the assessor to look forward, but down here it's prohibiting him from looking forward. So I'm not sure how this can be reconciled.
Could you state for the committee's benefit which provision of Georgia's Constitution you think this might violate? This back to the phrase, "in no event shall future use be considered."
The provision that requires fair market valuation of property in uniformity, that's what was amended before when the special carve-out was done for current use assessment for conservation use property.
Okay. Thank you. So we've got some technical issues here maybe to resolve. You want to continue, Mr.
Sure.
Ewing?
I think you all see a little bit of my members' frustration. I represent, obviously, all the county elected officials across the state, and they have the same frustration that you all do, that they hear that it's being done one way in a neighboring county and being done a different way in their county. And so a lot of this is about interpretation. We're getting different interpretations of what the law means, and that's frustrating because I know the taxpayer who may own property in multiple counties across the state wants to be treated the same and uniformly across the entire state. And so I think what Senator Rogers, one of the goals of his pieces of legislation is to try to get more uniformity across the state and how these things are being done. So you can't point to one county and say that they're doing it differently than everybody else, and somehow they see legal justification in doing that way. If you would, one other new issue that was included in this sub is on line 1218 of the bill. I understand that I think Representative Lindsay, you were asking for this change to be made to the bill. This, I think, what they're attempting to do here. We have situations in the state where counties will revalue certain areas of the county more often than another area. That typically happens where you have high growth areas. Let's take an area like around a lake, or in the metropolitan area like Virginia Highlands. Just areas of the county that, for whatever reason, are appreciating and changing in value more quickly. And it may not just be going up, it may be depreciating in value too. It may be areas where you have high foreclosure rates right now, where values are changing more rapidly. And historically, the assessors, they will do countywide revaluations. In some places, it may be once every 10 years or even greater than that. And this is a misnomer. I think some people think that the counties have to revalue all properties every 3 years. That's not true. There's nothing in state law that says how often they have to revalue properties. All it says is you've got to maintain fair market value. However often you have to revalue properties to maintain fair market value is what you do. And so what some counties will do is to try to maintain that fair market value, they'll reassess the growth areas more often than they do sort of the non-growth, or low appreciating or no appreciating areas of the county. This provision here will require the assessors, before they can come back and reappraise that growth area, they're going to have to reappraise every parcel in the county. I don't know if there's going to be a cost associated with this. My guess is what some counties will do is they'll say, hey, we reappraised the whole county and we left it at last year's value because we felt like there wasn't any growth in that area. And I can tell you counties are doing that now. But I just wanted to raise that to your attention that this is a new provision in the bill that wasn't here prior. But this is going to require your counties to reassess all parcels of property before they go back and reassess a parcel that they've already reassessed.
Also, to connect back to our prior discussion as it related to zoning, it's long recognized in the process that zoning will change value. This doesn't contemplate a rezoning. This just says that this sort of is a freeze up or down, which I wonder if that's really what the author wants, if no improvements have been made. But there are other events that we have recognized and we all have agreed in the past do have a value change derivative to them. That's one of those is a rezoning, not just an improvement. So maybe this needs some more sophistication as it relates to that.
I'd like,
Mr. Chairman,
Senator.
This was something that I met with Representative Lindsay about this morning as an idea he's had for a while, which I think is a good idea. We put in the bill, I'm, as the author of the bill, more than happy to go ahead and strike it and look at doing this at some other time after we have a chance to look at it more. So this is, I wouldn't want the committee to waste a lot of time on something because I'm more than happy to remove that language.
Okay, thank you. Go ahead, Dan.
I really don't have anything else as far as substantive provisions in the bill. There's probably a few areas that we'd like to tweak some language if there's another draft of this. I know that there was one provision that was put in here. It's another new provision on page 4.
12.
Before we move on to that, would you yield to a question?
Sure.
25, is that Representative Black?
Let me hold it until he gets through. I've got a general question.
Oh, okay. All right. Sorry. Go ahead.
The section of the 21-day notice.
12, page 12.
Oh, 12, okay. This was another new change, and I think it's on line 398. And I understand from talking to Senator Rogers, what he was after is really the 21-day notice, or now the 30-day notice. The situation that was raised was what happens when I appeal my property, the Board of Assessors agree that my property assessment is not correct, and they change that value, but they don't necessarily change it to the value that I asked for. They change it to some other value. Well, current law says they have to send me back a notice saying that they have changed my value. And then I've got, under existing law, 21 days. Under this new provision, 30 days to review that, determine if I'm satisfied. If I'm satisfied, I do nothing, and my appeal's over. If I'm not satisfied, then I have to go and basically tell the Board of Assessors, I don't agree with your change, and I want my appeal to continue, and it moves on to the next step, which is the Board of Equalization. The issue came up is, what if I don't receive that notice from the assessors, and I don't respond because I don't receive the notice, and my appeal administratively terminates and I don't get the opportunity to appeal, and now my time has expired. I think Senator Rogers, what he was trying to do in that section, which by the way starts on line 412, is give the taxpayer the ability to sign an affidavit to say, hey, I never got your 21-day notice, and if they do that within 120 days, they would be able to continue their appeal. I think that belongs in that section starting on line 412, not up in 398. 398 is the initial assessment notice that they send you, not the change notice. So there's some technical issues like that, but that's again, this bill has been well vetted. We've probably gone through at least 10 different drafts of this legislation since it was originally introduced in the Senate. Senator Chip Rogers has been more than accommodating to work with us and has addressed most all the issues that had been raised that were problematic. Again, I just appreciate the process. He started this process with a study committee in the fall, and I think that it does bring some needed changes to the property tax system. And ACCG has called for property tax reform for the last 5 years. We have actually been supportive of doing this type of initiative. We have felt like that our elected officials probably get more criticism for the property tax system than any other elected officials in the state of Georgia. And they see the need to provide more clarity and make sure that the taxpayer themselves has the ability to have a appeals process that is simpler and easier to understand and more efficient. And I think this bill moves us in that direction. I'd be glad to take any other questions.
We thank you. I don't see any questions on my board for you right now, but that doesn't mean it's the last time we want to hear from you. Obviously, we share your thoughts and your concerns that we're long past due with meaningful property tax reform. It especially adds some transparency and some predictability to the whole system. I mean, a lot of what we do is antiquated, especially with the technology that's available to us these days. And with the good faith and goodwill of most Georgians, that's not. We're not trying to correct wrongdoers here. We're trying to reform the entirety of the system and enhance its fairness and its equal application to all citizens of Georgia, which is what I think they all deserve to expect from their government. And I thank you and the ACCG folks for your hard work in this effort along with us. I have one last question for this sitting, and then I'd like for Senator Rogers to come up and have an opportunity before we break, because we have to go into session in a minute. But school boards are obviously a huge player at the table for property taxes, as are cities. Are you aware? Are there any issues that you're aware of in this legislation where there would be a conflict of their interest to those of the counties? Is there anything in here we need to be aware of from an unintended consequence standpoint that may impact our educational system or our municipal system?
I'm not aware of anything. There was one issue that was raised by the Department of Revenue yesterday, and it had to deal with the 3 and the 5% threshold for filing the digest. But after I talked to the Department of Revenue about that issue, I showed them in the bill where the school board can hold up the digest if they're not comfortable moving forward with the amount of properties in appeal, and I think that satisfied them. But you also are aware that Mr. Royal has been working on behalf of ACCG, the school boards, GMA, and the assessors this year. So by having Richard representing us, it sort of brought us together, and to my knowledge, he has not received any concerns from the school boards or the municipalities, and the municipalities have been involved in these meetings that we've been having since the fall on this issue.
Well, he's here, and he's always been with us here, and we're grateful for that, so we'll maybe hear more from him on that issue, too. I think all those organizations have to release him to speak since he sort of represents all of them, but I look forward to that. If we could get Senator Rogers up, thank you all very much, Mr. Mueller. And our friend from Gwinnett County, thank you kindly for your testimony. Senator, if you would, for the committee, brief us on the changes that were made, at least the ones that you're very passionate about. And
thank you, Mr. Chairman. I appreciate it. We thought we had a final product yesterday with the two what I would consider minor changes, and one of them you've already discussed, and I'll bring those to your attention now. On line 398, and I excuse me, I accept that this may need to be moved down one section, but this is a real problem in that if you think about the process, and I've said this from the very beginning on property taxes, it seems often that the whole system's weighted against the taxpayer. If you think about the process now, if you file an appeal and the assessors agree they need to change it, but let's say you believe the value is $100,000 less than their assessment, and they change it $1,000 less, they send you a notice. If you don't respond to that notice, your appeal is terminated. You may not agree one bit whatsoever that it should only be lowered to $1,000. You may truly believe that it ought to be lowered to $100,000. But if you don't respond, then your appeal is terminated. You can go no further. So all this is saying on lines 398 through 402 is that you have the opportunity, if you are willing to sign a notarized sworn affidavit, and I believe that would be a penalty of a felony if you lied on that you did not receive that notice and that you did not want your appeal to conclude and you want to continue. So maybe the 120 days is too long, Mr. Chairman. It doesn't matter to me where we change that to, but I think the taxpayer ought to be given an opportunity to say, hey, I didn't get the notice. I don't want my appeal to be terminated. The only other change, and this is really just a restatement so that we remove any confusion, it is on line 881 through 883. If you will notice on the preceding page on line 849 where we define the arm's length bona fide sale, we talk about unrelated or unaffiliated parties. Now, to me, that's very clear that that means when a bank takes back a property that they have the note on, that they're an affiliated party, so that would not qualify as an arm's length transaction. But just to make sure that no one considers a bank taking back their own property an arm's length transaction, on line 881 through 883, we redefine that again, saying, provided, however, that such sales shall not include a foreclosure transaction in which a lender acquires ownership under a security deed. Because as you saw by the board that was up here yesterday, what's happening is you have banks taking back the property, foreclosing the property. They have to go to the courthouse steps. They have to cry it out. But if nobody buys it at the value they're crying it out, they're going to take it back, and they register that transaction at an amount. Well, that amount is not a fair market value. That amount is most likely the loan amount plus all the legal fees that go on top of it. But that's not an amount that anybody in the fair market was willing to pay for it. So therefore, it's not a fair market value. And we just want to make sure that amount that the bank is taking back their own property on is not considered a transaction for the purposes of valuing that property. And that's all that does. We think we cover it with the definition of arm's length bona fide sale, but this further defines that's it. And then the only other change was the one I agreed we probably ought to not consider, and that was the one Representative Lindsay and I worked on, dealing with the reassessment of property and having to reassess every property before you come back and get somebody's property twice. So other than that, Mr. Chairman, that's the changes that were from yesterday.
Okay, when we concluded yesterday, we had not had a chance, the committee had not had a chance to have any questions or dialogue with you. We've just heard the responses, and I'd like to start that today and then maybe conclude that tomorrow.
Yes, sir.
And we'll be glad to meet again unless there's any other changes that come about it. And that's okay, too. Our interest is to get the best possible vetted final product that we can get. That's what this process is all about. There's nothing adversarial about any of this at this point. We're looking to get something that's meaningful to all of Georgia and understandable. 13, is that represented our whip, Lindsay?
Thank you, Mr. Chairman. Just very quickly, I want to echo what the majority leader had to say regarding page 35. The purpose here is to put an end to cherry picking reassessments in which one area or one kind of property is reassessed over and over again, and other areas and other kinds of property are not. In order to reach true uniformity, I think that all property should be reassessed on a timely basis. That being said, I believe that there's going to be a General Assembly session in 2011, and we can't cure everything every year. So unless we can get the language right, I have no problem with taking that out either. And I do thank the leader for taking a look at the issue of foreclosure sales, because unfortunately my county is one of the counties that is trying to use these kind of sales to bolster up values in particular areas. When, as the leader pointed out, these are not truly arm's-length transactions of a willing buyer and a willing seller. And we desperately need to have that clarification, because unfortunately my county is one of the folks who is misreading the law that we passed last year. That's all I want to say.
I want to make sure, Mr. Whip, I understand what you're talking about. You're saying that a foreclosure artificially lowered the loan amount, sometimes sale, distressed sale, bolsters values?
Well, in some cases it did, Mr. Chairman. It distorts the values because it's not a true sale by a willing buyer to a willing seller. And so all we're saying is that particular foreclosure sale on the courthouse steps should not be considered. Now, the subsequent sale by the bank to a willing buyer at the later time should be the one that should be considered, not the one that's done on the courthouse steps.
Mr. Chairman, if I could address that. What happens at the courthouse steps is actually a two-step process. Number one, and I apologize, I'm sure you already know this, but number one, they cry out the foreclosure, and anybody in the public can buy that at that amount. But, of course, what's happening most of the time now is nobody buys it. But if somebody does buy it, that's a legitimate transaction, because that's considered in here under our definitions at public auction. If nobody buys it, the bank will then take it back. But by definition, if nobody bought it, then that the fair market value was not established. The bank will take it back, usually for an amount that equals what was owed on it plus whatever legal fees. So the bank's taking the property back, but no one in the public was willing to buy it at that price, so therefore that's not truly a fair market value.
Well, no one other than the bank, but I would submit to you that the bank is a party, and they do buy it. They don't take it back. It's not a forfeiture. They actually enter a bid. They're allowed by law to bid.
That is true.
And they are a public entity in a sense. So that we're distinguishing a whole new class of transaction here, and I want to be. And I'm not saying I disagree with what we need to do. I'm just a little cautious as to how we need to do that. There's no automatic operation of law on a foreclosure. It's very, very statutorily specified who bids, who can bid, the hours of sale, where it's to be conducted, and the bank is allowed to be a bidder just like anybody else in public, in the public, and they can actually bid in excess of their loan amount and their cost involved in it as a party to the transaction. So I think we need to be a little cautious on trying to distinguish. What makes it an auction is if somebody other than the bank buys it. I'm not clear in this wording in this bill that that's what we're trying to do. If that's the intent, I think we can shore up the language a lot to do it. But the bank is a bona fide buyer at a foreclosure sale. That's not a forfeiture ownership situation.
I would agree with that.
So,
in the definition on 849, we tried to ferret out unaffiliated parties, and it was my belief that a bank even bidding on that property would be an affiliated party, and I'm not sure how we split those two. But I would leave it to your wisdom to help me find that definition.
Banks actually have the option to bid the property in under their loan amounts, and they
Absolutely.
create what's known as a deficiency, which is then a collectible in a judicial manner.
Correct.
By confirmation of the sale. So, I mean, there is a lot of law that we're impacting, I think, potentially, maybe indirectly, that we just need to be a little cautious about, that's all I'm saying. And Representative Lindsay knows it very well. He's quite a learned attorney himself. So, Chairman Williams. Chairman Peake.
Thank you, Mr. Chairman. I know that's the time we'll move quickly. I got a handful of questions. I spent about, when I was a young junior accountant, spent about 6 months going to Board of Equalization's appealing properties for a restaurant company, and after 6 months finally realized there was a total waste of time and energy because there was no way I could ever win. Maybe it was my lack of ability, but I through the process I realized that it was for the normal average taxpayer, it was extremely difficult. So thank you for doing this. My question to you, and I've got several of them, but the bottom line one is there anything that you think is brought about through this process that helps the average normal citizen who wants to go to a Board of Equalization and can't afford an appraisal to be able to defend their value of their property? In most cases, I guess we're now saying that you have to have an appraisal to be able to, or comparables. Do you think we're achieving the objective, though, of getting to where normal John Q. citizen can go and appeal his value?
Well, we've done some things to protect the property owner through the process of appealing. Of course, the main thing is making sure everybody has a notice of assessment, because I would imagine that the biggest frustration that property owners have is that they don't recognize their need to appeal until they get the actual bill, and at that point it's simply too late. And so that, if we did nothing else, would be the best thing out of this bill, is protecting that right to appeal. We've done some other things, extending dates, allowing other forms of notification that will help them. But I would agree with you that the underlying practice of the boards of equalization is somewhat problematic, and one of the reasons why we're here today. The creation under this language of the hearing officer, I think, is going to be a great first step towards eventually having no boards of equalization, but instead using true real estate professionals to process these appeals in a timely, efficient manner that brings some satisfaction to both the taxpayer and to the taxing authority.
If I thought just real quick, but the hearing officer, if I understand the bill right, is only for non-homestead property over $1 million. So the average citizen who may have a $150,000 home would not be able to use that hearing officer under the bill the way it's structured now. Is that correct?
That is correct. It is my hope and intention, and of course I may not even get reelected or even want to be reelected, but it's my hope and intention that if this is successful, we would the next step in future General Assemblies is we would expand that to all properties. But okay. That would be, while this is a major change, that would be a seismic change that perhaps we're not ready for until it's tested.
Okay. Sure. Ask one more quick question.
Yes, sir. Please do.
Board of Equalization appointed now by the clerk. In the past, is that not correct?
The clerk would only oversee the boards of equalization.
Not appointing the members, though.
Correct.
Okay. Good.
Yeah. And that's one of the problems we had, is really boards of equalization in current law don't really answer to anybody, and there's nobody overseeing them, and this at least helps keep that process under control. Representative
Black, you've been very patient.
I will raise a hypothetical situation and ask your evaluation of the impact of this would be were this to proceed on and become enacted. But is this going to increase the number of appeals that are made, or reduce the number of appeals, or keep them about the same in your judgment?
I would suspect, and my assessor here from Cherokee County, I don't know where he went, we use the process in our county of the annual notice to every property owner. And I think he told me, and he can certainly answer this, is you will have an initial spike because everyone's receiving a notice of assessment, but then that will come back down and level out. So I suspect appeals will go up. Without this, appeals are going up right now because values are not in line with fair market value. So whether we do this or not, there's going to be more appeals. If you do this, I suspect there'll be a spike.
Well, a commentary now on my part, in line with what Representative Peed made about appealing. In my judgment, in our county, a layperson can go down and research comparables and go, if he's willing to do the work, can go in and represent himself, and if there's justification, can get some positive results. But I also have been around long enough to seen some changes in the process, and I remember back in the 70s we had a situation that predated the Board of Equalization, and it had allowed for arbitration, where the county selected one person, taxpayer one, and they picked the third one. And the bottom line with that process is that the taxpayer would select a very aggressive representative, and the county's man tended to be a little bit less so, and the end result was that by arbitration, people got very favorable evaluations, and the perception got out within the community: you've got to appeal and go through the arbitration. If you don't, you're going to end up paying a greater share, and that puts an extra burden on the people and on the government. And I think this needs to be kept in mind in looking at any changes like this.
Okay. Thank you, Representative Black. Representative Powell.
Thank you, Mr. Chairman. I've got 3 questions. The first one deals with the line 94 in the new sub that deals with the, I think, the notice that's going out. And I think I understand this dealing with, it says, in addition, for non-homestead properties with a fair market value in excess of $1 million, you may appeal to a hearing officer with appeal to the Superior Court. That is in lieu of the other procedure. It's not in addition to it.
Correct.
Is that correct?
Correct. Yes.
Okay. So I have, if I have $1 million worth of non-homestead property, I have the option of going the Board of Equalization assessor's route or the hearing officer and the Superior Court route.
Correct.
Okay. I just wanted some clarification. I thought that's what it was saying, but when it says in addition, that means also you may do so and so, and that concerned me a little bit.
Do you suggest the language could be amended to better state that is an option and not?
Yeah. Yes, sir. I think later on I think later on in the statute it says option, but the notice is not clear to me, and I think perhaps that might be clarified.
And before you leave that,
yes, sir.
The fair market value threshold of $1 million. Who determines the fair market value? What if the assessor has it at $999,000? Does the taxpayer have the option to have his own fair market value determination, or is it the one that is on record with the assessors?
Under this one, it would be the one that's on record with the assessor.
Okay. I'm sorry, Representative Powell, please continue.
Thank you, sir. In line 343 of the new sub, which is dealing with the appeal procedure, I have, and I don't have any problem with the concept. I've got a little bit of question about if this is going to either be cumbersome or confusing, because it says any taxpayer, and taxpayers generally considered whoever owns the property on January 1st, or property owner as of the last date for filing an appeal, which means that if I sell it on January the 15th, and the problem that I see there without more is that there is a potential for 2 appeals, whoever owned it January 1st and whoever bought it January the 15th. And there's also the question of who's entitled to the notices and things like that that are sent out. And I think maybe just to avoid those kinds of problems, we may need to work on that a little bit. And I don't know what the answer is. I just see a problem that could arise as a result of that.
I think our assumption was, and maybe that's, I'm certainly learning in all my years here that assuming something is not good for the law. But our assumption was if a taxpayer had sold the property, they would have no further interest in appealing it. But they may. But the property owner, as of the last date for filing an appeal, would certainly have that. We were trying to cover both cases, but I hear what you're saying. We certainly don't want that property to be opened up for both parties, I wouldn't suspect.
Well, and you also have the situation, I think, where maybe I sell it on April the 1st, and I've already filed an appeal. Do I transfer my appeal or do I pursue my appeal? And I just think that probably, certainly whoever's going to wind up paying the taxes probably wants to be able to pursue that, and that may need just a little bit of work. And then my final question is dealing with the requiring an assessment notice to be sent to all property owners even if there hasn't been a change in value. And there are two things that concern me about this, because there was a bill that came through the House that dealt with sending out tax bills with an additional line of information saying if you disagree with whatever it shows as the value here, that you can put in your own, and that basically constitutes a return, which triggers the appeal. What that did was, number one, it avoided having to send out tax bills and send out assessment notices on properties that had not been reassessed. And for those folks who had not had reassessments, they would avoid that mailing cost from the county standpoint. The other thing that did, because it had all the information that you're requesting in the assessment notice, as far as the value, the millage rate, the not estimated bill, but the actual bill, whereas the potential problem I see in sending out assessment notices to people who have not had a change of assessment, because it may not include all the exemptions that they're entitled to. If I'm, over 65 or over 70, and I'm no longer in my county required to pay school taxes or some portion of school taxes, or I get an additional homestead or whatever it may be, and that's not included in the information you get, I may have the same millage rate that I paid last year, the same assessed value that I had last year, and yet the notice I give indicates that I may be paying more tax this year because it doesn't include all of the exemptions. And so it may generate appeals from people who normally wouldn't appeal, and that gives me some concern, and I'd like you to comment on that if you would.
We wrestled with that for quite some time on how can we have the absolute most accurate information when sending the assessment notice with the estimated tax on it. We believe that, particularly in the age of, like in the two counties I represent, seniors essentially don't pay property taxes for the school portion. We believe a lot of that information will be available and can be included on that notice for that specific property owner. But there's no way that we could find, and maybe you know more or somebody knows more, there's no way we could find to make sure that we had the exact information on every taxpayer when we sent out the assessment notice. I think we can get awful close to what that value may be, and that's why we included the language of the value may be more or less, trying to give us some room there. But I'm certainly open to anything that could help us get closer to the actual tax, what it will be.
Okay.
Thank you,
Mr. Chair, for those very insightful questions. I have 3 questions left, and we have 15 minutes to be in session. And let me say this, and it might be that we suspend here and let these very patient people, Representative Abrams, Chairman Knight, and Chairman Martin, maybe they can speak to you privately, or we will reconvene with their questions first tomorrow. What I would ask the committee to do, though, my goal tomorrow would be to work toward a finished product which would include any proposed amendments. So if you can, overnight, before you get back tomorrow, we're going to try to meet, I think, at 10 in the morning. We don't go until 1. Are y'all in at 1, or when do you know?
Well, according to your leadership, we're both going in at 10 tomorrow. But
Oh, we are. It's 10 now. Is that right? Does anybody? Somebody just told me 1. So you're our leadership.
I spoke with my counterpart in the House and earlier this morning, and the suggestion was we may both be going in at 10 because of some of the significant bills that would be on the floor tomorrow.
Well, how about if we try to meet at 8 then? Is that all right with everybody? Can everybody make 8 o'clock in the morning? A caucus. How about 9? Rules. Well, let me. What I was getting at is, regardless of when we do this, as a courtesy to the majority leader, if anyone on the committee does have an amendment, or if you conjure up one overnight, if the majority leader would be so inclined, if you could come like 5 or 10 minutes before the meeting, or have your staff folks, whatever is most convenient with you here, I would ask that anybody that intended to be recognized for an amendment to this legislation, please have the courtesy of letting the majority leader review that prior to the meeting. I realize you don't have to do that. I'm not ordering you to do that, but there's a strong likelihood you'll be recognized a lot sooner if you do. And this is not just a joke, and that was funny, and I didn't really mean it to be, but this is very serious business for the people of this state, and I really do want to emphasize, I want to get it right, and I'm real proud of y'all, regardless of your political affiliation, on the way we vet legislation, and I do think we get out of here a quality product, and that's our goal in this case. So if you would. If you can do that, if you can be here early or have somebody here early, I would ask that anybody cover their amendments with the majority leader or his designee. Now, as far as tomorrow, we are in at 10. There's a caucus meeting at 8, and rules is at 9. So I suggest then we're just going to have to meet at adjournment.
Tomorrow or today?
Tomorrow. Okay, well, let's do that then. And then if we have to reconvene after session, we'll do that. We want to give this the time necessary. I'm going to go ahead and announce, I think we're going to try to set the meeting for 9 in the morning. Those of you that have amendments, Representative Powell, certainly I think you've made some great suggestions on clarity type amendments. We're very interested in those. Please, if you can, get those worked on overnight. Lindsay Napier can help y'all, even though she's sick as a dog, but still working 14-hour days. She can't even talk, but she can listen and write. Or Joe. So we'll try to do that, and until 9 in the morning, we stand adjourned. Thank you.
Thank you, Mr. Chairman.